Good evening, 26th of May 2022, the Facebook Live Observation Post Weekly Report. Funny thing is, I forgot to put it out there. Usually I do it 2 or 3 days early, and I forgot to put it out there today, so I just posted it, so I'll go over them quickly. I don't want to be doing this all day, and I bet you people don't want to listen to me ramble on all day. So, the first point I said, and this don't affect me because I wasn't part of the Manouche case, but when you take somebody on in court and you win, you get damages to repay you for whatever harm you suffered. So I said tax on the SISIP settlement. The government called the payment premiums, so they cannot call the payments income to be taxed under Income Tax Act Section 61F, having already legally classified the payment to settle the legal dispute as something other than damages. Income Tax Act Section 61F5 allows for the premiums to be deducted from taxes before taxes are charged, and for the entire settlement premiums are supposed to be tax deductible. Now, that's sort of a leap of faith, but the thing is that they painted themselves in the corner as far as I'm concerned, because they wanted to put the money into the Manulife bank account so that they could then pay the veterans who sued the government the money that was owed to them. But instead of calling it damages or income, the government labeled it as premiums. Now, premiums are something you pay to buy insurance ahead of time. Premiums are not what you get after you win a case in court. Enough said. As far as I'm concerned, the government should not have charged taxes against the settlement to mitigate their damages. Number 2, compare and contrast exceptional incapacity allowance versus the permanent impairment allowance / additional pain and suffering compensation. I haven't done it yet, but I can do a bit of it on the fly. The government decided to do, at least as far as I'm concerned on many other veterans, to replace one-for-one different things that were in place before the new Veterans Charter, and they gave them new names under the new Veterans Charter. So the exceptional incapacity allowance, which is payable under the Pension Act, it's payable to anybody with a 98% or higher disability assessment according to the table of disabilities. So basically, they wanted to replace it one-for-one, and they created a 5-grade system under the exceptional incapacity allowance. They put a 3-grade system under the permanent impairment allowance, but in the law you could not get both. Now, this was despite the fact that the government said the purpose of the permanent impairment allowance was to replace promotions and seniorities, and they labeled it an economic benefit. But the exceptional incapacity allowance is for things like loss of lifespan and pain and discomfort and disfigurement. So I think they meant that these things were supposed to be the same, which is why they said in the law you couldn't get both. Now, it don't make any sense to me, because if they said that the Pension Act was for pain and suffering, which is bullshit, but they said it was. Now, they said that was non-economic. If you're going to replace it with an economic benefit, it's absurd. It's not reasonable. Now, over time, we know that the government changed the name for the permanent impairment allowance. They first called it the Career Impact Allowance, and then they called it the Additional Pain and Suffering Compensation, and along the way they made it tax-free, and they reduced the levels to 2006. That isn't right. It basically eliminated the inflation protection between 2006 and 2019. Number 3, because I don't want to be at this all day, like I said, people might think that I like attention. I don't. I wouldn't be doing this if other people were doing it. Automatic SISIP for reservists would have minimal cost to the government because Veterans Affairs Canada claws back SISIP long-term disability, but this problem exposes the self-interest or greed because the Department of National Defence does not want to pay. They would prefer that Veterans Affairs Canada pay or no one pay. Section 41A3 of the SISIP policy must go. Now, what I'm talking about there is the provision normally a term in a contract is negotiated. So you would sit down with the party you wanted to negotiate a term into a contract with. You would hammer out a deal. Whatever you agreed to will be put into a contract and it will be binding. Now, Section 41A.3 of the SISIP policy states that unless a reservist is hurt on duty, they cannot get the service income support insurance money. Now, that limits the amount of money that the Department of National Defense has to pay, because imagine that you have a non-visible, an invisible injury. How are you going to prove that you had, say, depression, anxiety, or anything like that, PTSD, if you can't see that, without an expert, a medical opinion? So this allows them, and I posted with the my weekly report, I posted a picture from, I did up a spreadsheet from data that I obtained from the Parliamentary Budget Office report, and it showed the number of people that were medically released between 2007 and 2013. And the reason I perked up on this is that there was class of service was there. So on average, about 350 reservists are medically released per year. But only 22 on average get SISIP. Now that has to change. You can't have two different classes of individuals. It's discrimination. Now, anyway, so they should get rid of that. They never should have put it in there. You had to be injured on service for Veterans Affairs stuff, but to make it for the Department of National Defense Insurance is clearly insane. Now, so basically, as far as I'm concerned, to make sure people understand my point, if you get medical release, you have to get the insurance that you paid for, whether you were hurt on or off duty. That is the way insurance is supposed to work. If the risk happens and you bought insurance, you paid the premiums to obtain coverage, you have to get the coverage. Now, the very same argument also rules out clawbacks. Because if you buy insurance, the risk happens, and then someone says, well, you have clawbacks of the Canada Pension Plan or the Canadian Forces Pension, then why did you buy insurance? See? So clawbacks are also supposed to be, outlawed. I agree, Robert. Two classes, that's but it shouldn't be in theory. Okay, I've heard, I haven't seen it because I was out since 2012, but I've heard they pay reservists the same as regular force people now. Don't know if it's true, but it makes sense. Because it comes down to a similar situation like women and men getting different pay for the same job. At least in my opinion. I think a lot of people would agree. It's common sense. Okay. Clawbacks of married but disabled people's insurance and pensions when the spouse owns half. Now, that's just an idea. I'm going to expound on it a bit. I've been trying to help a lot of veterans who have ended up going through divorce. Now, another thing that occurred to me was when I was having my Canada Pension Plan deducted from both my Sun Life, which they're still doing, and Manulife, which they stopped because they stopped. I said to the Manulife person at one time, pensions are property and my wife owns half. So at most you ought to be able to only take half because the other half is hers. Now, people might not agree, but that's the way it is. The case that makes me say that is Clark versus Clark, Supreme Court of Canada, 1990, which was a Canadian Forces Superannuation Act veteran, an annuitant, who became divorced, and they had to decide, was the pension property or income? Now, each one had its own legal ramifications. At the Nova Scotia Court of Appeal, it was determined to be income. Then it was appealed to the Supreme Court of Canada, who pronounced that Canadian Forces Superannuation Act pension is property that can be divided in a divorce. Now, if the Canadian Forces pension and the Canada Pension Plan, obviously, and the Public Service Pension and the RCMP Superannuation Act pensions are all property, then they can't deduct the value as income as a clawback, because they're not legally income, they're legally fucking property. Now, I wrote a note to myself in my field message pad. And the note, you know, is for a later show, but I'll mention it now. Facts are facts, okay? You might disagree with the Supreme Court, but you are wrong if it's been to court and it has been decided, and you decide that pensions are income. Well, you're wrong, okay? That has already been litigated. The answer is clear, and you can go fuck yourself, okay? So anybody who argues with something that has been adjudicated in the highest court in our country, they're fucking wrong. You get it? I mean, it's obvious. But you know, I had this conversation with a potential member of Parliament running against Seamus O'Regan, and he happens to be a lawyer for McInnes Cooper. And I was wanting to know what his views on things were, because, I mean, if he had to beat the Liberal guy, the Conservative guy, then he would have been my member of Parliament. And he said that pensions can be both income and property. Now, he and I had an argument about that. Because, I mean, I expected a lawyer to understand that a Supreme Court of Canada judgment is a law. They have decided on that judicial fact. Now, once a case has something, I mean, this is a bit of law, even if I'm not a lawyer, you have a fact that's in dispute. It goes to court, and it could be 50-51% in the judge's mind, but once it's been determined to be this or that, it is then considered to be 100% true. So the judge might have been 51% pretty sure he was right, so he rules in that manner, but after the ruling, it is 100%, not 51, not 52. It's 100% accurate, unless, of course, it can be appealed, which the Supreme Court of Canada, there is no appeal after that. So the thing is, it really rots me to see people try to twist things to try to make things appear to be something that they're not. And that's one of the reasons recently I was looking up the definition of misinformation and disinformation. Because it seems like in Putin, over in the Ukraine and Russia, they're using a lot of disinformation, which is completely fabricated. But you can also have misinformation, which is not as bad, but it's still bad when you have someone say something that's not true. Now, in tort law, that would be called misrepresentation. You can have innocent or not so innocent misrepresentation. Someone might believe something to be true when it's false, but they're still guilty of misrepresentation if it's proven in court, because they're trying to get you to accept something as true when it's not true. See? Anyway, the disabled Canadian veterans privacy problem. Now, this is something I was thinking about as a column idea, something that I could, you know, put out that here's what I'm thinking about writing something up on. Because, believe it or not, people might think that it's about the money, that, you know, that I'm trying to get fixed, and they might call me greedy. No, it's about accuracy, accountability, and making sure that you don't screw people over. So, the thing about a clawback, if they didn't have your personal information, they wouldn't be able to claw back, would they? How can they reduce the value of your income replacement benefit by your Canadian Forces pension if they're not allowed to know how much you get, or if you get a Canadian Forces Superannuation Act pension? If you get the Canada Pension Plan Disability, what could they do if they're not allowed to have the information? Then how can they claw it back? Now, people might say, well, we gave them consent. Yeah, but did you give it willingly? Did you give it knowing all the facts? Did you know about the Privacy Act and what it's supposed to do? So the Privacy Act is supposed to protect private lives of Canadians. Now, presumably that includes disabled veterans. So if the government needs information to run a program, it's allowed to collect it. It is supposed to collect the information directly from the individual whenever possible. It is also not supposed to collect the same information twice. Now, one of the reasons I thought about this is that the Veterans Affairs Canada didn't believe me when I said I was medically released and I wasn't getting SISIP. I got a letter from Veterans Affairs, and they said, please sign the enclosed VAC 928E consent form for us to get information about you from Manulife, because you said that you weren't getting SISIP even though you were medically released. in essence, they were calling me a liar. Now, the problem I have with that, besides the fact that it drove me up the fucking wall, because I was arguing with Manulife around the same time that I should be getting SISIP because I was medically released, which is what Veterans Affairs Canada said. Now, me and VAC were on the same side. I should be getting SISIP. But I wasn't getting SISIP, so can you imagine the frustration I felt when the government sent me a letter calling me a liar, but agreeing with my position? It fucking rankled. So, the other point I'm trying to say here is that these people try to say that these programs are integrated, that they have coordination with a program arrangement. Now, if you have similar programs, then you do not need a consent form. Okay, so if you have two programs, Veterans Affairs Canada's Income Replacement Benefit, and you have the Department of National Defence Earnings Loss Benefit called SISIP. Now, they have a program arrangement because they say they're similar programs. In fact, the Auditor General said in a 2012 file report that they shouldn't be duplicating programs. But the thing is, they're not duplicates. They're entirely different. One, the Service Income Support Insurance Plan, is a premium-based insurance plan that was forced on the soldiers in 1982 when they made premiums be deducted automatically, mandatorily, by passing the Queen's Regulation and Orders 208.53. Before that, you could choose whether or not you wanted to buy the Service Income Support Insurance Plan. So, you have the government taking away freedom of contract, the right to choose, back in 82. And then you say that these programs are similar. You set up a program arrangement in 2006, updated in 2012. In the program arrangement, in section 3.2.1, you say that the Service Income Support Insurance Plan will be the first provider of income replacement in the case of a medical release. Now think about that. That is the exact opposite of what they did for the Pension Act. Because the Pension Act was the first payer before, and then the Service Income Support Insurance Plan would reduce the Department of National Defense legal liability under a contract of insurance. But under the new system, they reversed the whole system, and they said that the Department of National Defense Insurance would be the first payer, and then Veterans Affairs Canada would top up the D&D program. But the problem is neither one of them wants to pay. So when they have a clawback, like the Canadian Forces Pension or the Canada Pension Plan Disability, neither will acknowledge the other one doing it, and therefore they both do it, which harms the disabled veteran because they had the money being deducted twice. So for every dollar you get in the Canadian Forces Pension or the Canada Pension Plan, you could lose up to two. You'd lose one off the Department of National Defense Insurance, and you'd lose one off the Veterans Affairs Canada insurance. Because that's what the income replacement benefit is. It's a form of insurance. But instead of having a premium-based, where you could see the money being deducted from your pay, they basically have service as the payment. Sort of like workman's compensation. The employer pays the premium. You know, the premium is actually how much money they pay out. Anyway, I'm thinking about doing a column on that. Now, another interesting fact, because my head is full of trivia, is that there are many laws. I looked it up, and there's 42 laws that have the power of an inquiries minister given to the minister. So under the Veterans Affairs laws, under the, the Canadian Forces Members and Veterans Reestablishment Act, or the new Veterans Charter, and under the Pension Act, if they ask someone for information, they have to provide it. So they should not have sent me a letter saying, please sign that consent form. They should have sent an inquiry to the Department of National Defense, and they should have said, tell us if this, veteran, Captain Retired Matt Edwards, if he's getting any Service Income Support Insurance Plan. They could have ordered the Department of National Defense to comply. Now, if they had said, we can't give you that information because it's protected under the Privacy Act because there's no consent form, that wouldn't have stopped them, because in order to get SISIP, you sign a blanket consent form. So you sign, part of the package that SISIP sends, you give Manulife the right to give information to other people. Then there's the program arrangement. So these people are trying to abuse us by taking in our personal information when they have no right to get it, first of all. Because if they didn't have the information, how can they claw back? I mean, people would say, well, we have the right, like the Privacy Commissioner did an audit in 2012. In October 2012, they reduced 95%, I believe, of the Veterans Affairs employees' privileges about privacy, and they stripped 500 people of their right to look at other private information at all. So that's a pretty big deal. So they sort of gave the government a pass, even though it's bullshit, but they did say there's one problem we have. Although the government's entitled to get the information for, say, the rehabilitation program and the earnings loss benefit program, well, they don't need both at the same time. Because if you get denied access to rehabilitation, then there's no need to collect information under the earnings loss benefit application form. Now, technically, they're right. Because of the way VAC tries to sell this bullshit, they say that the program is rehabilitation, and the benefit is the rehabilitation program, but really, money is the benefit. Rehabilitation is a condition of benefits. So basically, they don't really need two applications, but they crapped on VAC for collecting information prior to it being required. Now, I would take that a step further for my example with the VAC 920AE form that they sent to me in November of 2012. And I would say that they collected personal information with no requirement because my signature and other personal details were on the consent form. Okay, so they collected personal information that they had no requirement to get. Now, I don't think it's worth making a complaint to the Privacy Commission because I've tried that and they seem to shoot me down. And that's what I was saying about that audit in 2012. They said that the government has the right to collect the information because of the law. Now, that's where they didn't look at it close enough as far as I'm concerned. Because if they look at the fact that the government wrote a law, the new Veterans Charter, and in order to administer the new Veterans Charter, it needs personal information. Now, that's well and good, but do they need the information twice? See, if they have the information that they can get from the Department of National Defense simply by sharing the information, then if they collect the information for the second time, they are not only wasting government resources by, those people could be getting paid to do something else instead of doing the same work twice, but they're also breaking the Privacy Act. Because the spirit and intent of the Privacy Act is to collect the minimal amount of information required in order to administer a program. So if the information resides in a personal information bank, PIB, at the Department of National Defense, then there's no need to collect it again and put it in a a VAC personal information bank. Then you've doubled the privacy collection. You've doubled the risk of privacy breaches. You're not supposed to operate the government like that. You're supposed to be a good steward of the taxpayer. You're supposed to try to use as little tax money as possible. So these people think they're covering the bases, because even in the program arrangement, it says that both Veterans Affairs and the Department of National Defense will continue to collect their own consent forms. They put that in there, and they think they covered the bases because they put it in writing. But the first thing I would say is, okay, listen, you jerk. You sat down and negotiated a program arrangement, the three parties. Okay, you have the Department of National Defense, you have the SISIP Financial Services, and you have Veterans Affairs Canada. Who gave you the authority to sign away the rights to the disabled veteran? Because Section 3.2.1 says that the Department of National Defense Long-Term Disability will be the first payer of income replacement benefit, which means that they'll claw back the value under the income replacement benefit. But you bought and paid the SISIP premiums. You paid for that with your service, with the money you got from your service and your service. So who in their fucking right mind would give away something for nothing? See, the government thinks that it pays both insurances, and basically it's given us two different payments. That's their mentality, and that's why they put in controls to try to save money, because they think they're paying us too much. Now, next one, draft up a scale where each positive and negative action results in a clear picture of how fair the government is with respect to the disabled. Now, what gave me the idea of that was, I was thinking about the scales of justice, okay? They're supposed to be even, right? So sometimes you have something that's positive and sometimes you have something that's negative. Well, the thing is, it's very seldom that something is clearly right and wrong. But when you take someone's property, as an example, which a pension is, and then you deduct the value of that property from an insurance plan, and you call it income because it suits your purposes. Well, that's not so easy to say, well, there's right and wrong here. Because first of all, you lied about the legal nature of the payment. Okay? Everybody should know that pensions are property. If you want to try to say that you have the right to take it into account, then you ought to call it property, because that's what it legally is. So you can say, we're going to reduce the long-term disability payment by your return of your payments, your return of your property under the Canadian Forces Superannuation Act pension. But they call it all income. And they think that by calling it all income, because they're like from like, well, we can deduct this form of income from that form of income because they're the same. But they're not the same. Insurance is property. Pensions are property. Income is income. But income is something that you earn when you're healthy, right? Now, I was thinking about using this later, but I'm in a play game called War Thunder, and a lot of the guys that I play with right now are living in Australia. Now, one of them is a veteran, and he was telling me about today about this welfare type thing, income support thing, and they have a point system. So, evidently, you're allowed to have this much money and make this much income, and it won't affect, your welfare if you don't add up to a certain number of points. And I said to him, well, I consider myself a bit of an expert from all this stuff I've been researching here in Canada. And I would call that point system a form of surveillance, because they want to keep an eye on the disabled. They don't trust you, and they want to reduce money to taxes for the able-bodied people who pay taxes. Because think about that. Who pays taxes in general? It is healthy people that can earn a living in the general labor market. So when the government said, for example, in 2006, well, oh my God, the pension, the costs are escalating sharply. Basically, they were saying we should pay less so that the healthy taxpayers won't have such a big burden. Their hard-earned work, they got to pay these disabled veterans who won't go to work. That's what they were saying. So they brought in a system that's sort of like workers' compensation, and it deducts everything from your payment. But the thing is, you're not allowed to do that. See? If you get injured by someone else, they are supposed to make you whole. They are supposed to put you back in the position that you were before you became injured by their fault. That's the tort law system. Now, there was a lot of trouble back in the early 1900s about businesses thinking they go out of business because of, lawsuits. So they agreed to have what's called the Great Compromise. So the worker gives up the right to sue, and the employer has to pay all the premiums for a workers' compensation insurance system. Now, although soldiers aren't employees, the government views soldiers as sort of like employees, and they said that you gave up the right to sue in order to get your Pension Act pension, okay, basically. So in order to enact that, they put into the Pension Act, Section 25, that said that if you sued someone for the same thing that you got an injury in military service, you got a Pension Act pension from, then they would deduct the dollar for dollar from your Pension Act pension. They would convert your lump sum payment in lawsuit in tort into a monthly Pension Act type payment, and they would reduce the value of your Pension Act pension. Now, that was for the government, but if a civilian hurt you, they would only reduce your Pension Act pension by half. See? So they wrote a law which is absurd on the face of it. Prima facie is the Latin phrase. Because how can you have a law that reduces, on the one hand, for the government 100%, but a civilian that you sued only 50%? How can you claim that's fair? The government put it in the law a perk for itself to allow itself to reduce the pension by 100%. That's garbage. Now, the other one was workers' compensation. It says that if you got workers' compensation for the same thing that you're getting a Pension Act pension for, they would reduce your Pension Act pension by the value of the workers' compensation. Two problems that I can think of offhand with that. The first thing is that the government has, at the federal level, a thing called the Government Employee Compensation Act, GECA. Under GECA, a soldier cannot get workers' compensation under Section 3, brackets 1. So, why the fuck did they put it into the Pension Act that if you got workers' compensation for the same injury that you got the pension for, that they would deduct it? It's a stupid law. The government's not supposed to make stupid laws. It makes them look bad. Now, the second one that comes to mind is that the provincial governments who make workers' compensation laws, they want to save money too. So you can bet that the provinces would like to claw back the value of the Veterans Affairs payment just as much as Veterans Affairs would like to claw back the value of the workers' compensation. So Bob is watching, Bob Grant, a sergeant retired, and this problem came up for him. I hope he doesn't mind me saying, but Veterans Affairs Canada, they took into account his Canada pension plan. Now, the provincial workers' comp in Nova Scotia took half of his Canada pension plan into account. So for every dollar he got from Canada pension plan, he lost $1.50. $1 off the Veterans Affairs income replacement benefit, and 50 cents on the dollar from the workers' compensation. Now that's not supposed to happen. Now the workers' compensation law in Nova Scotia states that no one can claw back the value of the workers' compensation. Every province in Canada has those laws. That's because you're supposed to protect the compensation paid to a disabled civilian. It's not supposed to go to somebody else. It's supposed to go to the person who was hurt. Because the right to sue is a personal right. So that you gave up a personal right, the right to get damages if you get hurt, if you're on the job, in order to get administrative and comprehensive workers' compensation. So basically, to clue it all up, because I'm tired of talking, my eyes are going blurry and whatever, to clue it up, these bastards have created a very complicated mess. A veteran I talk to a lot, Arnold Murphy, would call it a racket. Canada doesn't have racketeering laws like the United States. But I agree with him on the principle. They want us dazed and confused. They don't want us to know that, well, the federal government has to obey the provincial laws when there is an overlap if the province has the jurisdiction. Like workers' compensation is part of provincial law because they own labor, right? So contracts and stuff like that are provincial. So that's why we have all these different workers' compensation systems in all of the different provinces. They have a different system. But defense is federal. So because defense is federal, then Veterans Affairs Canada has to have a national system for our national military, and they are supposed to replace the right to sue with some kind of compensation. But as again, what happens is things go through my head. Okay, so compensation. One of my key points is that I believe the government don't understand the definition of the word compensation. When you're healthy and serving in the military, you get compensated for your time, and I use in my head a little c. You get paid, compensated for your time with an income, with a salary. If you become injured, you get paid compensation with a big C, because that's like damages. Your body was hurt, and you get paid back in kind. So your body is capital, not income. So if you get paid damages by a private person that hurt you, you're getting capital payments to replace a capital loss. So if the government replaces the right to sue, which gives you capital to replace your bodily loss, with money that is not income, you're getting paid not because you work for the person who hurt you. You're getting paid because they screwed up and they injured you. Now, this is the problem. They don't understand, or they choose not to understand, that the definition of the word depends on the context. So compensation in terms of a service at current time is small c and income. Compensation with the capital C after you get injured is capital, not income, and therefore they're like apples and oranges. But they use the same word, and it's very confusing. Okay, it's like when they used the pension for the Pension Act pension. They should have called it some other name. Okay, it's sort of like damages, almost exactly the same. So I don't know what name they could have come up with, but anything but pension. Because most people think of pensions, think of a retirement pension. So by using the word pension under the Pension Act system, they really, cause a lot of people confusion, right? They could have called it veterans compensation. They could have called it anything but a pension. Because if you look, here I'll add a little bit of confusion too. Mr. William F. Nickel in 1916, when they were developing the pension, he was asked something about what is it, and he said, listen, this is the veteran's property once it's awarded. It isn't up to us to tell a person what to do with their property. We're not going to make them go to Sunday school. In other words, he was going to say, we're not going to try to tell him how to live his life. You could take your pension, or if you were injured by a civilian, you could take your damage and you could piss it away on drugs and booze, and it could be all gone relatively soon, a year or two, and then you got nothing. But that's your own individual responsibility, and the government shouldn't have any say in what you do with your property. Did that make sense? But see, here I wanted to shut up, but I can't. When the government put out this big lie that the pension was pain and suffering, well, if they designed it as property, I don't see like something intangible like pain and suffering as property. See? How can you label something that is legally property, capital, and then you call it pain and suffering compensation? And, just to make it even more complicated, I guess, this was already heard in court in 2002. The Sarvanis Supreme Court of Canada case in 2002 was about the Canada Pension Plan Disability, and the Department of Justice lawyers tried to call it a pension, like the Pension Act pension. Now, they did that because the Crown Liabilities and Proceedings Act, Section 9, stated that if you get a pension for your injury, then you cannot sue the government. So, it's supposed to stop people from getting paid twice for the same injury. And everybody should agree with that. I agree with it, and I hope you do. But they were trying to pull a fast one because the Canada Pension Plan Disability is paid out like insurance. You pay the premiums ahead of time, and if you need it, if the risk happens, this is I'm repeating, paraphrasing what the Supreme Court of Canada said. Now, that begs the question, if the government already was sued, because that was the one who got sued, the government, and the Supreme Court of Canada ruled that in 2002, then how can the government tried to say that the Canada Pension Plan can be clawed back from income replacement benefit or SISIP. They ought to know, based on the precedents, that this is off limits. Because one of the main things that the Supreme Court of Canada said about the Canada Pension Plan disability is that it's non-indemnity, which means it doesn't compensate for anything, and contributory, which means you bought it. So this is one of the main reasons that nobody is allowed to claw back a non-indemnity and contributory payment, is because only indemnity insurances have the right to claw back, first of all, and they only have the right to claw back other indemnities. See? So if you get indemnified from here, and you get indemnified from there, and you get lots of money, and you end up with more money than you lost, well, everybody would agree that's wrong. But when you're dealing with life insurance or disability insurance, because you don't know the value of those things, they will never be indemnity insurance. They cannot compensate you for any loss. You might think you got compensated because you got money, but really you were paid in relation to the contract according to the terms agreed to. That's what it's all about. Listen, I look at the clock there. I'm running out of... I don't want to be at this all night. My eyes go blurry when I'm at this bullshit. But I really wish I didn't have to do it, okay? I hope everybody understands that. Because what the government is doing, and this might be controversial, it's only a matter of degree between what Putin is doing over in the Ukraine when they want to take somebody else's land. You know, they want to take that country, but they don't want the people. Well, the government wants to claw back things from us, and they make us apply for the Canada Pension Plan disability even if we don't want to. Shouldn't we have free choice? Shouldn't we have free will? Shouldn't we be able to say to SISIP and other people, get stuffed? You want me to apply for my Canada Pension Plan disability so you can save money on the Department of National Defence Service Income Support Insurance Plan? If I'm not going to get any benefit out of that, go fuck yourself. Why can't we tell them to go fuck themselves? Now, it's not life and death right away, but people probably could commit suicide or something. I mean, I'm just putting it out there. I mean, it's a speculation in a way, but all of this shit and abuse they put on us must have a negative effect on our psychology, our psyche. So you could also run into food shortages and other stuff because, I mean, okay, the government could, and I don't know if I covered this before, or probably did, they usually do, there's a limit on SISIP for the cost of living for inflation factor, but there's no limit on the Pension Act, for example. So one of the things that I was saying on the cost of living, for years, even though the Manouche case is settled, supposedly settled, in the past, you could have been losing money every year because the Pension Act could have had a higher payment, more than 2% on the cost of living, which was the cap on SISIP. The Pension Act could have given you 10% more. Now, because SISIP was capped at 2%, that meant that 8% more was being deducted because they were taking into account the COLA, the cost of living, on the pension. They're not supposed to take the cost of living allowance into account because it's placed into the contract as a term in Section 24B that the cost of living allowance on a clawback amount is not considered to be relevant income for clawback. So they shouldn't be clawing back the cost of living on the Canada Pension Plan, the Canadian Forces Pension, or the Pension Act. But they do. They do it all the time. They don't even see it as wrong, even though it's a clear term in the contract saying that they won't do it. They do it. That's one of the things that if I ever get off the ground about getting them sued, it will start off with something simple maybe. Take them to court about the fact that they don't make the payment at the 30th of the month, like the last day of the month, like it says. Either they pay it early or they pay it late, but they certainly don't pay it at the end of the month. Now, either way, they're in breach of contract. If you pay it early, you're not adhering to the term of the contract. If you pay it late, you're not following the term of the contract. So pick your fucking poison, you son of a bitch. Pay it on time, like the contract states, or you are going to be sued. Now, it's hard to say what the damages are there, see? That's one of the problems with this. Even in my own case, you know, about the cost of living one, when I called up Manulife, I worked it out, it was something like $600, right? I mean, that's pretty small potatoes, right? But it's still $600 that they could have avoided becoming possibly, you know, legal liability for if they simply did what was stated in the policy. Listen, I'll be here all day. Thanks for watching and have a good weekend. And one of these days I hope to say, you know, hey guys, I started a class action or something, but I just don't trust the system much right now. Anyway, thanks for watching.